Glenn, let me start with you. If you were building a case around January 6th, what interests you most based on what we learned yesterday?
You know, I would like to think I would build a case much as the January 6th committee investigative team of former federal prosecutors has built the case that they're now presenting to the American people. I mean, it was pretty breathtaking, Jonathan, when we learned that John Eastman, who was deeply involved in the plot to overturn the election's results, at one point sent an email to a Penn staffer that said, you know what? Let's engage in just one more relatively minor violation of the law. Even, after the riot, he was still advocating for overturning the election's results. And, what is implicit in the statement that John Eastman made? Let's engage in one more relatively minor violation of the law. He was acknowledging that he had engaged in earlier violations of the law. There is nowhere left for John Eastman to run. I mean, if there's any justice in our future, John Eastman will become a guest of the Federal Bureau of Prisons at some point for the crimes that have been exposed by the J6 committee.
Joyce, there's a big difference between presenting a case in public, like the committee is doing, and presenting a case in court, like the Justice Department would do. Talk about those differences, and are there advantages that the DOJ will have in its grand jury investigation?
Well, it's obviously easier to be the committee presenting evidence because you don't have to worry about the federal rules of evidence like the Justice Department does when it tries a case. For instance, rules against hearsay that would apply at trial don't apply, and the committee is exploiting those differences and using them to great effect. That's not to say that DOJ couldn't find ways to get this same evidence in an admissible fashion, but it's some work, and the Justice Department lawyers will have to be very careful to make sure if they do decide to indict that they've got all of the evidence that they need. The advantage that they have, of course, is federal grand jury subpoena power. They can force witnesses to come without having to jump through all of the hoops that Congress has had to jump through. They can force them to come and testify before a grand jury. They can obtain documents in that same way more readily and more easily. So for the disadvantages, they're meted out by the advantages that the feds have when they prosecute cases. Nonetheless, it's a lot easier to be an armchair prosecutor. Glenn and I both know this to be true than to be the federal prosecutor who's actually sitting down, evaluating the evidence against the elements in the statute and making sure that you're ready to go.
Glenn, the January 6th committee said in a statement today they're cooperating with the DOJ's request for transcripts of its witness interviews. Let me read from the DOJ's letter. It is now readily apparent that the interviews the Select Committee conducted are not just potentially relevant to our overall criminal investigation, but are likely relevant to specific prosecutions that have already commenced. Given this overlap, it is critical that the Select Committee provide us with copies of the transcripts of all its witness interviews. As you are aware, grand jury investigations are not public, and thus the Select Committee does not and will not know the identity of all the witnesses who have information relevant to the department's ongoing criminal investigations. As a layperson, Glenn, I know what I think about this, but what do you make of that letter?
So, I think that letter shows that the Department of Justice is on a mission, and it's a mission in the grand jury to present all of the information, all of the evidence from the witnesses that the grand jury will need to assess whether there's enough to indict anyone. And, if you're putting a witness in the grand jury, Jonathan, and you know that that witness has also given prior sworn testimony to a congressional committee, you have to get a hold of that information to assimilate it into your grand jury presentation. Because think about it. What if there are inconsistencies in what that witness said in the grand jury versus before a congressional committee? That could undermine the quality and the credibility of the evidence that witness has to present. So this looks to me like the Department of Justice wanting to be thorough. And let me add this, and I think I can probably speak for Joyce as well. There may be information that's been developed by the J6 committee that is helpful to some of the defendants, what we call Brady evidence. And, you know, the Department of Justice, I think, has a moral, if not legal obligation to try to get a hold of that information as well. I don't want to go into a tutorial about whether it's in the government's possession, if it's in the executive branch versus in the legislative branch, but it's the right thing to do because even insurrectionists and Proud Boys and Oath Keepers are entitled to a fair and full trial and defense. So for lots of reasons, I think it's important that the Department of Justice get everything from the J6 committee to make sure their grand jury investigation is solid.